I so wish I could have been with you. Nairobi, a city in which I worked for 15 months, vetting judges in Kenya. Bright, energetic, lively city, a conference beautifully organized and a theme that touches our deepest humanity and provides some of the biggest challenges that legal people can have in all the work that we do. But things have cropped up. I can't be with you, but I do have a story to tell, and this is what I'm going to convey now. And it begins with my arrival in England, 1966, a psychological wreck, a refugee, a psychological wreck. I'd been in solitary confinement for 168 days in South Africa, wearing me down. 2 years later, back in solitary confinement, sleep deprivation, banging, loud noise, silence, going through the day and the night, collapsing on the floor, water poured on me, my eyes prized open. It was hard. On the boat to England, stateless, a refugee. There was a wonderful organization called the Society for Protection of Science and Learning that had been set up in the 1930s in England to receive refugees mainly from Germany and some from Italy, from Nazism and fascism, intellectuals. It would have been people like Freud and Einstein and brilliant people like that, and people whose names weren't known, weren't famous, but all fleeing from persecution. And now, sadly, after World War II, still very busy, very active, receiving refugees, helping them, in that particular case, people who had some kind of academic vocation. I was down. I was angry. Angry at my government, angry at apartheid, angry at having been forced out of my own space and life, and forced out not for doing bad, but for doing good. But I was also angry. I found strangely angry at Britain, the country that was receiving me, maybe projecting onto them my sense of total displacement, but saying, if it hadn't been for you, the British, granting power to the whites in South Africa and establishing, through support for the mining houses and so on, the whole system of laws and controls and so on, pass laws, migrant labour, Britain, 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 Britain. It was a strange emotion that instead of feeling love and affection for the country that's receiving me, I had that sense of disturbance and rejection mixed in with the love and the support. And I was aware of how irrational it was to attack the very place and space that was providing me with a home, with comfort, ability to marry, to have children, to write books, get a PhD at Sachs University. That was the first time I arrived. I then went to Mozambique, armed with my PhD, new confidence, to help with the development of a new legal structure, newly independent Mozambique. Got my courage back, got deeply involved in the reconstruction of that country, sang the songs, shouted the vivas, the slogans, queued up for rations, shared the difficulties, blown up. So the second time I arrived in England, I arrived as a physical wreck, having lost my arm, sight in one eye, and yet in a strange and rather beautiful way, this time I learnt not just a gratitude to the host country, but a kind of love, and that came from the nurses cleaning my wounds, that physical laying on of their hands on my injured body through the National Health Service in England gave me an emotional effect and a connection with the home country. And little realizing that it would be important for me later on in my life, shortly after leaving hospital, I met up with Professor Barbara Harold Bond, who invited me to a refugee study centre in Oxford. It was tucked away. It wasn't one of the important institutions there in one of the important buildings. And she wanted me to speak about my experiences as a refugee. I remember I spoke at maybe my first public speech after coming out of hospital, and I collapsed. My legs gave way and everybody came crowding around me, and I pushed them away and I carried on talking afterwards. And it was hugely enlightening, because the whole purpose of that study centre was to reconfigure the nature of being a refugee and having rights as a refugee. Getting away from simply you have a right to asylum, okay, that you're not going to be tortured, persecuted, beaten up for who you are in the country of your origin, and a right to be given food and shelter. That's not enough. They were saying you have a right to live as a human being, a right to work, a right to learn things from the country you're in and to give things to the country that you're in. That the idea was not to place you in a camp somewhere so that you merely survive, but to integrate you into the society to which you were going, so that you can participate in the life of the new country you're in. You can draw real deep sustenance from it, and you can give something of value to the country that you're in. Total reconfiguration of the nature of being a refugee. Today we take so much of that for granted, but these were completely novel ideas, and some of the biggest problems she had was with good people working in the area, working in the United Nations, but in a very top-down, paternalistic way, looking after these poor creatures who've had such a hard time, to say these are not poor creatures who've had a hard time. These are human beings who've been through hell, human beings who are now finding opportunities to rediscover themselves as human beings and being embraced by the countries in which they are, in which they find themselves. When I was imprisoned for the first time in South Africa, I felt every judge should spend at least one night in prison. Do you know what it's like to be locked up totally under the command of somebody else in a strange, concrete space? When I was a refugee once and a refugee twice, I felt maybe every judge should be a refugee, but of course you can't fake that, you can't manufacture that. But there's something in that subjective experience that's so profound and dislocating. So much irrationality enters into your soul and spirit because of the very nature of the experience that you're undergoing. So much of your vulnerability is carried with you, a certain sense of dislocation, and so much of your joy at simply being safe from persecution. It's almost an irrational joy, a superb joy, gets mixed into this being that you have, this strange being of being somewhere, being someone, but not being somewhere specific, real to you, and being someone, the person you were before you were displaced from your country of origin. So fast forward to Justice Albie Sachs sitting on the Constitutional Court bench in Johannesburg and dealing with the Union of Women Refugees case, which had come up to us from the High Court. And it dealt with a clash between our refugee law that in South Africa, I would say, was very, very progressive now in our new democracy. So many of our people in government had been refugees. We were so aware of how lives of human beings could be totally disrupted through things over which they had very little control, how important it had been that particularly the countries in Africa had received us with a wonderful embrace and paid a heavy price for receiving us. I was in Mozambique. Mozambique was bombed. Its electricity was destroyed. Railway traffic was diverted to bring down the economy. Armed groups were encouraged to fight Frelimo, fight the government, because they supported our freedom struggle and because they received into their workspaces people like me, Albie Sachs. So we had a very powerful emotion in favor of progressive refugee law in which they'd been suffering, to asylum, but entitled to live lives of dignity, of productivity, of worth. And our refugee law then granted to refugees a right to work on the same basis as South African workers. That was absolutely vital. And then the opportunities of, through residence for a certain period, of acquiring residential permits to live and work as free people in our country. Law, clear, progressive. You don't go into camps. You're not subjected to that kind of control, paternalistic and rather futile existence in camps. You become integrated into South African society. A separate law from a separate ministry in government dealing with security forces, private security, and a certain concern that private security could be utilized by people maybe hostile to our democracy, our development in the country, and a provision in the Act dealing with private security saying in blanket terms only South African citizens can belong to the private security firms. Non-South Africans, aliens, different terms might have been used, are not entitled to join private security firms. There's a caveat that the minister concerned, the Minister of Home Affairs, can grant permits for people in that situation. And the Union of Refugees, or Women Refugees, and the Union of Women Refugees, an organization set up to help women and their menfolk who'd fled from persecution in different countries in Africa, from Congo, bitter civil war, from other parts of the continent, bitter civil war. Fleeing had arrived in South Africa. Many were working, the men, some of the women, as car guards, and they said this is depriving us of the small but important sources of income of self-reliance, of certain dignity, of not living simply on handouts or things that we might scratch here and there, but through the work that we're doing, the contribution we're making to South African society. And they challenge the constitutionality of that provision. Our Bill of Rights, very, very strong, and it includes amongst its provisions an equality clause that forbids discrimination, unfair discrimination, on grounds of national origin. And they rely on that in their challenge. So now I'm sitting up on the bench. The High Court had, I don't even remember exactly what the ruling was, but in any event, it's for us to decide. And I'm surprised to discover that I'm not the most, if you like, radical person in terms of outcome in favor of the applicants, the Union of Women Refugees. My colleagues, Kate O'Regan and Yvonne Mokgoro, say quite simply, it's clear that discrimination is operating against people because of their national origin. They are being deprived of the right to work in the same way that South Africans could work. Full stop. I'm looking at it from the point of view both of the women refugees and legitimate interests that the government might have in terms of security. And I'm thinking there are different classes and categories of security agents. One of the key things required for security, VIP protection for government ministers and so on, well, that would come from the public service, but where private security is involved, is to have background checks on the security people in relation to important installations and so on. And the problem with refugees is you couldn't get those background checks. So I felt that a limitation that said that you don't have a right to work in security operations that deal with particularly sensitive, important economic, political, social, cultural institutions, parts of the country, to say, wait 5 years to show a clean record would not be unreasonable. And so mine was a more nuanced response, if you like, to the response of my colleagues. But I felt that the blanket exclusion was unconstitutional, and I felt that there should be a clear right after 5 years, clean record, right to residence, then you should have an absolute right to work anywhere in the security services for private security. So I wrote a more nuanced response. It's not me, Albie, just as the former refugee, emotionally fighting for the dignity and rights of refugees now in my country, but Albie the judge, having had that experience, being aware of the context, understanding the importance of balancing out all the different interests involved, gave protection to the refugees, but not as blanket and as strong as my colleagues Yvonne and Kate had done. We got consensus on the court as a whole. They didn't even accept my position, my colleagues. The majority of the court, however, struck down the notice that had been issued by the Department of Home Affairs on more limited grounds, not per se as being in violation of the Equality Clause. They struck it down, and I agreed completely with it, that it was too blanket, too sweeping in its nature, very, very technical as far as getting an exemption was concerned, not in the languages that people could understand, and that the Home Affairs had to completely reconfigure the processes in terms of which they granted or refused to grant a right to work in these particular cases. So the whole court could agree on that the process was unfair, it violated the rights to just administrative action. We struck it down on that without taking a stand, without getting a unanimous position on whether the exclusion of refugees from working in private security per se was unconstitutional. Coming back to the work that you're doing, I can only reinforce the importance of it, the importance of principles, deep principles of humanity pervading the issues of migration. Migrants are not simply wishing to joy walk through the world, disregard frontiers, different countries and so on. They're compelled to move by everything from starvation to persecution. And that's what makes this conference such an important conference, and that's why I'm so eager, even if I can't be in the room with you today, at least here I am. Fire your questions, give your responses, produce your challenges. Here I am, I'm with you at least for a little while to respond as well as I can.